Okay, Bob, the floor is yours.
All right, good afternoon. Thank you everyone for joining us. This is timed to be about 35 minutes without any stops for questions. But if you have questions, type them in the chat box, please. Ernie will read them to me, and we'll take the questions as we go along. There should be at least 15 minutes or so at the end for questions. And again, let me emphasize, this is a rare opportunity to talk with an ALJ. You don't get to talk with sitting ALJs at Omaha. The only ALJs that go out and give talks are the chief judge and the deputy chief judge, and they're not giving talks like this or answering questions like this. So, did you know that doing one thing can establish you as a knowledgeable representative, get you paid sooner, and quite possibly head off CMS participation at the pass? Yes, a proposed decision can do all that. I'm hearing it more and more from clients who are telling me the judges are asking them to submit a proposed decision either with a notice of hearing or during their hearing. One of the things we're going to talk about today is submitting the proposed decision as soon as possible. Ideally, we should be submitting it with the request for hearing. Right? The ancient Greeks used to say the gods help those who help themselves. So how do we do that? We do that with a proposed decision. And so where do we start? We start with our preparation of the case. And if you're the treating physician or the treating therapist or the equipment supplier, your preparation begins when you make the treatment notes, when you see the patient, when you sell the item of equipment, and so forth. And because you're the treating practitioner or you're the DME equipment provider or the therapist or the home health provider, you know that patient better than anybody else. So you're going to be much better prepared than the rack doctor, the quick doctor, or anyone else appearing in the hearing. You know that file better than anybody other than the beneficiary. So what you want to do is ask yourself, as you're preparing for this, what do you want the ALJ to do? You want the ALJ to pay your case. Why should the ALJ pay your case? What's the reason that Medicare should pay for what you did to the beneficiary? This involves preparing a line of facts. You do that, as we're going to see, by making a timeline. You apply the law to the facts, and you come up with the reason why the judge should pay the case. Many lawyers do their case preparation, and they start with their closing argument, or what lawyers sometimes call a summation. And so if you're writing a proposed decision, and by the way, those of you who are submitting anything to the ALJ, be it a position paper, pre-hearing brief, you're already doing and writing all the things that are going to be in a proposed decision. All a proposed decision does is format them in a different way. What you're doing is you're giving the judge a final product. You're showing the judge that you want a particular result, and you're helping the judge give you that particular result. All right, so everybody's entitled to their opinion, and the opinion of the appellant is that the case should be paid, that Medicare should pay for what you did for the beneficiary. Right? The saying goes, everyone's entitled to their opinion, the lawyer has to prove it. And so we have to, oops, went the wrong way. We have to watch out for red herrings that CMS contractors are throwing at the ALJs. One of the favorites is this that they told us as ALJs back in training 6 years ago during the Judicial Education Symposium. That's an excerpt from 93-1 HCFA ruling. And the rest of the story. And because you're prepared and because you're knowledgeable representatives and you're aware that some CMS contractors don't tell the whole story, don't cite the proper LCD, misstate the LCD, you've read the entire ruling, and you can respond during your hearing, and you can respond in your proposed decisions analysis section with the rest of the story, as Paul Harvey used to say. And you know this because you prepared your case and you begun preparing your case well in advance of the hearing. And you're able to do this because you're honest. All right, so what do we need to know about some of the changes that were sent out in notice of proposed rulemaking, excuse me, that was due in August? I got a little bit of a bronchitis here. From time to time it acts up. I'm sorry for the break here. The proposed change here says that the ALJs can't just say, I adopt the proposed decision. Excuse me. You know, if they're going to steal, to quote Austin Kleon, they have to steal like an artist. They have to do their own work. So the proposed change does not mean that you're unable to submit a proposed decision, that the ALJ is not going to look at whatever you submit. All this says is that the ALJ can't say, I adopt the findings in the appellant's proposed decision, or I adopt the findings in the appellant's proposed brief. They have to do their own work. And I think this arose out of a situation that we had shortly after I started as an ALJ. So that some ALJs were not even signing their own decisions. They were using a rubber stamp. And the decision is a payment voucher. And so the contractor is not going to pay the case without a signed decision. And I actually saw an email go around to the managing judge saying, hey, you guys need to sign your decisions and don't have your legal assistants do a rubber stamp. So this could be some of the history behind this change. Right. Another thing you want to keep in mind is that CMS policy, something other than a ruling, is not binding on the ALJ. The ALJ has to give a deference. This is in the PowerPoint, so I'm not going to belabor it. The key here is that whatever you hear from the contractor and whatever you see in the denial letter and whatever you think CMS may be telling the ALJs is never, like we used to say in the Navy, never give up the ship. This was on the wall in the hospital where my mother was, God rest her, after she had her stroke. Right. So why a proposed decision? Again, it shows the ALJ that you know your stuff. It helps them help you. It lessens the workload. When I was on the bench, even a year and a half ago, it was as much as 90 days after a hearing to get a decision out. So if you submit it, you know, for the judge after the hearing or shortly before the hearing, and you've cut the time to your decision, in an ideal world, you're submitting it with your request for hearing. And the law of primacy says we tend to go with what we first look at or see, and your proposed decision is going to be knowledgeable. It's going to be in a format that the ALJ is used to. It's going to make sense to the ALJ staff attorney, and the legal assistant or the staff attorney is going to look at this and say, hey, judge, we got a proposed decision here. This might be an on the record, and you convince the staff attorney you've won half the battle, and you get paid a year and a half, 2 years sooner, and you don't have to wait for a hearing. You get to spend your time treating a patient, taking care of clients, taking care of customers, instead of dealing with the system. Right. The key here is brevity. Right. The actual quote is, people are busy and they're begging you to be brief. That's a typo, a misstatement on my part. You know, the key is brevity, and the key is plain language. Right. Try to avoid government speak to the extent that you can. Use regular English. Tell the ALJ what you did for the beneficiary. You know, there's a magic in somebody walking in an emergency room because they've got an episode of 3 days of asthmatic bronchitis, and you're hooking them up to albuterol mixed with oxygen, and they're walking out of there and not coughing during a presentation. That's probably not going to be an inpatient case. But years ago, somebody would have been burned at the stake for doing something like that. And you did something for this person, and you deserve to get paid. You made them better. You helped them maintain their level of functioning. You saved their life. You worked hard. Your staff worked hard. Your people worked hard. your client worked hard if you're a representative, and you should get paid for it. Okay, so all the ALJ wants to know is what you did, and in your writing, just say it like it is. You know, that if you take a look at some of the quick decisions and some of the redetermination decisions, that's not plain English, it's government speak, and you want to make it as easy for the ALJ to follow what you're doing as possible. So now we're getting into the templates. This is boilerplate. I'm not going to spend a lot of time on this. If you include this in your proposed fully favorable decision, then what you're doing is, again, you're showing the ALJ you know your stuff, right? I mean, this is something that's at the very beginning of every decision that comes out. As far as the procedural history, I don't think you really need to get into a lot of detail. You just, hey, we filed our timely appeal, and, you know, we have jurisdiction. If you didn't file your appeal on time, you wouldn't be having the hearing anyway. Again, this is more boilerplate that we don't, excuse me, need to spend a lot of time on. This is something that was not in the original set of slides that I sent to Ernie, and they just went out. If you're asking for an on-the-record decision, then this is what you're going to use for procedural history instead of the last slide. You know, forget the thing about the hearing. You know, again, as some people will say, a hearing was not held and this favorable decision is issued. But again, one of the things I emphasize is using active voice. Do we have a question? I can hear somebody in the background. If you have a question, type it in the chat box and Ernie will read it.
No, that's just me. I was just coming on because I wanted to ask you to just explain that a little bit more. This is the kind of phrase you put in if you're asking for an on-the-record.
Right, and that. So if you're sending this with your request for hearing, and you know, for example, it's you know, an inpatient rehabilitation after a double joint replacement, and believe it or not, those are being denied, or if it's an inpatient admission for total hip replacement, and I can't tell you how many of those came across my desk that I just didn't catch, then you really know that that's a case that the ALJ really should be paying on the record. And so, you know, if you want the judge to pay the case without a hearing, you put this in your decision. Again, this is something that the staff attorney isn't going to have to write. At the end of the day, when this thing is done, you're going to send a paper copy to the ALJ. You're going to send a copy on a disk, you know, just whatever it is, a CD, you know, that goes into a computer. 3.5, not floppy disk, you know, a CD, a compact disc type thing, and send that with the ALJ, because then what they do is they pop it in their computer, they open it up in Word, and they make whatever changes. They don't have to re-keyboard all of this. So again, this shows that you've been around, that you know the ropes, that you know what you're doing. The ALJ is going to take a look at this and say, hey, you know, it's like being in the military. You know, if you show up in your uniform squared away, or you show up for a job interview and you're wearing a suit, you know, instead of a bathing suit, or jeans and a T-shirt. I mean, you know, that might, jeans and a T-shirt might work for tech, but you know, but it shows that you've been there and you know the lay of the land, and you know, you only have 3 seconds to make a first impression. And when the ALJ sees this with the request for hearing, the ALJ is going to, or the staff attorney is going to, you know, this person, you know, they've obviously done their homework and they know their stuff. Let's take a look at the rest of it, and you know, they're going to be inclined to agree with you because you're doing it in a format that you like. You know, it's like if you're an attorney and you have the client in a criminal case show up. Well, if it's a military case, you don't have a choice to show up in uniform, but get your uniform cleaned. Don't wear it to the courthouse, you know, change in the bathroom. You're squared away. If it's a civil case, you know, the client shows up in a suit. They look respectful. The jury walks in or the judge walks in and sees that you prepared and that you care. And so when you do this, you know, it's little things that count.
Yeah.
All right. This is an optional thing you can throw in. You know, and again, this just shows that you know your stuff, and that after more than 10 years, some of the contractors don't. The ALJs sit in original jurisdiction. They do not affirm anything. They do not overturn anything. And so, you know, you used to see a lot of these word process papers that say, you know, affirm the decision or the prior decision is correct. Well, this is a de novo hearing. You know, you're starting again. and there's really nothing there. And so again, you're just showing the ALJ that you know what you're doing, and the RAC or the contractor doesn't.
So,
Right. So the nitty.
I'm sorry to interrupt, but you mean that like the Macs and the RACs now probably aren't doing that kind of thing anymore, where they're asking the judge to affirm, but
Well, I don't know.
Yeah.
You know, I don't know that, you know, those of you that are down in the trenches probably know this better than I do. You know, but if you're encountering this, then you can throw, you know, if you've seen this in the prior denial, then, you know, you can throw this in at your option. And again, you're telling the ALJ, well, first of all, I realize you sit in original jurisdiction. You're making the decision in this case. You run the room, Your Honor. And,
Okay.
you know, I understand the program here, and I'm with the program. The nitty gritty of this is the timeline, okay? Because again, you know, everybody's entitled to their opinion, but you've got to have facts to support the opinion. You know, as the saying goes, facts without opinion are trivia. Trivia without opinion, or opinion without facts, is baloney. And so what you want to have here are actual facts supporting what you do. And so we start with the beneficiaries. I lost the cursor here. I don't know why. We start with the beneficiary's date of birth. The next thing you want to put in here is any past medical history, the event that precipitated the admission. You know, the broken hip, the heart attack, the fainting, the loss of function, whatever. If it's in an inpatient case, and again, this is an example. You know, if you have some questions, type them in the chat box, and you know, I'll be happy to answer them now or when we get done with the presentation. You know, the date of admission, the date and time of admission. We're going to see this in the next couple of slides. Dates of service. You know, these are the dates that the beneficiary was in the facility, the dates that you were rendering home health services, the dates that, you know, you were seeing the beneficiary, and then typically the last item in your findings of fact is going to be the day the beneficiary, the doctor, discharged the beneficiary from the facility, or discharged the beneficiary from care, or the therapist discharged the beneficiary. And again, using active voice. All right, so let's look at a few of these findings of fact. These are not in the templates. Let's look at, go back here. This is we have a 85-year-old woman who comes into the hospital with a prior history of a stroke, a heart attack the first time she was scheduled to have her hip replaced, and goes through the procedure well. And you've got a denial from the from the RAC saying, well, the beneficiary tolerated the procedure well. So again, we start off with a standard of proof here, which is that the following facts were established, by a preponderance of the evidence, right? You want to recite that all the time. It's not active voice. You know, in an ideal world, the decision would say the appellant established the following facts by a preponderance of the evidence, but this is the way it's always been done, and this is what judges are used to seeing. I mean, it's in Social Security decisions, it's in administrative decisions all over federal and state administrative agencies, so just run with that part of it. All right, the first finding of fact, the beneficiary's date of birth. You're telling the ALJ how old she was on the dates of service. And then you see in bold blue, there's a citation, which is something that you can do at your option. If you do it, it helps the ALJ, it helps the staff attorney. And how do you know what page number is going to be in the file? Well, what you can do is when you submit your request for hearing, you submit a page numbered copy of the medical record. Since it's a copy, it's not new evidence. And you don't have to worry about new evidence submissions or possible remands back to the quick under the Affirm Act, if that ever passes. And so you leave the exhibit number blank and you just put the page number in from your page, in your page number medical records. And I've actually had an appellant do this. One or two appellants did this with almost every case that they submitted to me while I was hearing cases. And it was just extremely effective because I could just tell the decision writer, particularly if it was on the record, agree, you know, cite to this page and we're going to call this, you know, exhibit number 3. You don't know what the exhibit number is going to be. You will once electronic filing fully takes place and you can access the file somehow. So just leave the exhibit number blank. All right, so the rest of it.
I was just going to say that's, you know, that really, I think that's a really key thing for people to keep in mind, because I know there's been a lot of questions on rack relief or other things that I've seen. And it came up this last week on the special edition of Finally Friday. We were hearing that the ALJs really do like it if you send them a fresh copy of the medical record, because otherwise what they get is a copy of a copy of a copy.
Exactly. Yeah, good point. Thanks for bringing that up.
Yeah.
You know, I can't tell you how many times during the hearing I'd have to tell somebody, you know, I'm, you know, Dr. So-and-so or Miss So-and-so, I can't read this. I think this is what it says, and, you know, send me a copy because, you know, the decision has to be based on the evidence. So, second finding of fact, you know, I mean, you can read this stuff for yourself. You know, again, we're talking about the past medical history, significantly that this is an actual case. It was my mother, God rest her, although it didn't wind up to be an inpatient. But, yeah, somebody had a, you know, it's telling the judge, you're painting a picture here. You're preparing the surface. You know, you're helping the judge. Somebody, you know, the first time they were scheduled for the surgery, they had a heart attack. You know, and then they came in and they had these issues. You know, your physical examination, you know, and then let's go to the next to the last slide, or excuse me, the next to the last finding, and in red, because this is a red herring that the quick or the rack is going to throw at the ALJ to not pay the case in the denial. Well, the beneficiary tolerated the procedure well, so she didn't need to be an inpatient. Well, number one, you know, you're not going to type this in red. I just put it in red, you know, so we can all see it. But you're dealing with an adverse fact. You're showing intelligently, you're showing integrity, you're showing honesty. You're dealing with something that could possibly hurt your case. And this also shows that it's all right to do a finding of fact in a persuasive manner. You don't just have to, you know, drone out facts. You can actually be a little bit argumentative. I mean, you're not really being argumentative with saying, although the beneficiary tolerated the procedure well, her blood pressure spiked. I mean, you know, being argumentative would be saying the quick lied or the quick didn't tell the whole story and you should pay the case. That's argument. That's argument. You don't want to do that. You can be, but you can be persuasive. You know, you don't have, you know, you don't have to necessarily just say the beneficiary tolerated the procedure well. Next finding of fact, her blood pressure went up to. You can paint the picture for the ALJ. You know, this is advocacy. This is turning, you know, the sow's ear into a silk purse. And we'll talk a little bit more about that, you know, when we get into, you know, leaving against medical advice or early discharge and so forth. So you've dealt with this adverse fact. You've sort of, you're turning the ALJ a little bit in your favor here as you go on. And, you know, so what did you do for the beneficiary after the blood pressure spiked? Well, you know, give her IV hydralazine, and you include a table here, you know, with the times and the findings and so forth, and the last column is, you know, I'm not a doctor, so I'm not sure what the dosages would be. I just, you know, pull those out of the hat, but you know, put in what the dosages are, and then your next finding of fact is, you know, that Dr. Welby changed the status to inpatient at, you know, 7 o'clock the night of July 21st. And directed, you know, 15 minutes or every half hour and titration of the medication. And, you know, this is obviously a case under the pre-October 2013 rule, before the 2 midnight rule. And, you know, it would seem very obvious that, well, gee, this case should have been paid on the record. And this, what, you know, I've seen cases like this where, you know, you miss it. You know, I mean, there's tons of paper to look at. And so this is where a proposed decision that's backed up by a fact that, you know, yeah, the doctor really did change the status to inpatient here. And, you know, the judge is going to see this before October of 2013. And the staff attorney, you know, is going to take it in and say, hey, you know, Judge, I think we don't need to have a hearing on this case. And, you know, so the rest of it, you know, is yeah, so some of the facts are true. Some of them I pulled in from other cases and so forth. This is the one of the templates that we sent out, and again, it's just got boilerplate findings of fact. You can pick things that typically are seen in inpatient cases, and you just use the ones that would work for your case. You see here, the last two findings of fact, the attending physician wrote an order admitting the beneficiary as an inpatient, active voice, instead of the beneficiary was admitted as an inpatient. Well, who admitted the beneficiary as an inpatient? You know, again, keep in mind you're getting paid for what you did for the patient. The order included the following reasons, if it did. We're going to talk about how to deal with an order that doesn't, or an order that doesn't necessarily say inpatient in a few minutes. You know, the status change here. All right, not in the slides, but something that we can talk about a little bit is what you do with the law. You can, if you want to, insert a section called legal framework. And there you'd put in the relevant portion of the HICFA ruling, the entire HICFA ruling if you wanted, you know, order the law, you know, Medicare Appeals Council rulings and so forth. It's not really necessary that you do that. I think the staff attorney will probably fill that in if they decide the case. They have sort of boilerplate example decisions for an inpatient admission in a situation like this that they're going to use. They're going to pull the law out of, you know, essentially what they're going to be doing when they write the decision is writing new findings of fact and writing an analysis. So I don't think you need to worry a lot about boilerplate, but this is somewhere where knowledgeable attorneys like Jess or Abby or David would come in, and in writing your findings of fact, a knowledgeable consultant like Deepak could be helpful. So the analysis should explain why the judge is doing what they're doing. You know, you're going to take the facts and apply the facts to the law, make a finding accordingly. But one of the key things that you want to do, and this is underscored by some work that a couple of clients just sent me in the past couple of weeks, is that the analysis should explain why the facts meet the legal requirements. Okay? Simply regurgitating the policy, which is typically what the contractor does in their memorandum, that's not analysis. Okay, regurgitating the facts is not analysis, you know, and so I get, you know, a series of denials from a couple of different clients, you know, and the gist of some of the decisions is, well, the beneficiary didn't have pain or the beneficiary didn't have this, but they never really go on and say that these findings didn't warrant a particular level of service or these findings didn't warrant whatever. They just regurgitate these facts. I mean, it's the same thing that's in the finding of fact and that's in the analysis, and then there's a sentence that says, yeah, the case is not payable because the requirements are not met. But it never really says why. And so this brings us back to, you know, facts without theory is trivia. Trivia without facts is baloney. Back when I was on active duty in the Navy, this was like 92 or 93, I think, and my parents were still alive, and I went to see a movie with them in Phoenix starring Mel Gibson. He was this offbeat, sort of solitary character that lived on a cabin on the coast of Maine, and he'd had some horrible accident. His face was scarred. This kid liked him, you know, just kind of wanted to, kids are curious and they wanted to know what the deal is, and they started hanging around together, and he was tutoring him. And every now and then the kid would ask Mel Gibson's character some question that he had obviously not thought through, and Mel Gibson would yell at him, and he would say, think, reason, and he would insist that this kid go through a logical analysis and think it through for himself. And that's what your analysis portion of the decision is supposed to be doing. You know, you're supposed to be connecting the dots for the ALJ and connecting the dots for the reader. So you're writing this proposed decision for the ALJ because you want to persuade the ALJ to pay. You're also writing this decision for the beneficiary who's going to get a copy of it. You're also writing this decision for the AdQuick, who's going to look at it to see if it's legally sufficient, and for the Medicare Appeals Council, who may look at it if it gets appealed by the AdQuick, and for reviewing federal district court. So you want to keep these readers in mind. And, you know, again, one of the things that I consistently saw, and when I was a decision writer at Social Security, I remember the first review that I got from my supervisor said, he's actually saying why, he's reaching the conclusion that he did, because so many administrative agency decisions, all they do is they recite the facts and they recite the policy, but they never say, well, but this doesn't fit. And so what you really want to do, the best way to put it is, you're connecting the dots for the ALJ, you're connecting the dots for the reader. And so here's just one example. If I can get this, I can't get my cursor here. So it changed status. I can't read the whole slide because I got this thing at the top that's blocking it. And so this is a situation where you're actually explaining why the ALJ should pay the case, even though the facts would appear to be against you. There isn't anything on the face here that said he admitted the beneficiary was an inpatient. But if you look at this, you don't, when you say continue to do this every, 15 minutes for so many hours, or continue to do this for a couple of days, again, ALJs are people, they stuff gets past them, you get busy, you miss it. Sometimes it's hard to read. It may be a bad copy, and this is another reason that you want to send in a brand new copy of the medical record. And again, cite to that you're finding a fact. And then again, the next paragraph. So you're saying why, that it was clear in the record that this person was going to the hospital for at least 24 hours. So because of that, I'm paying it. I mean, that's all it really takes. But people aren't doing that. All right, the other red herring that they always throw out, unexpected recovery. Well, the beneficiary wasn't in the hospital for 24 hours. The beneficiary checked out early, or the beneficiary got better. Well, what do you think they're going to do at Resurrection Hospital? They're going to make people better. But, because you're a prepared representative, because you're a knowledgeable physician, because you've been doing these cases, because you prepared your case and you've thought this through, you can ask the physician, or if you're the representative who's testifying or the expert who's testifying, keep in mind that this is still as much an art. It's not an exact science. The textbook might say that somebody who's 85 that has these symptoms and presents with this condition is probably going to have a particular result. But, again, like the guy in the Monty Python movie, I got better. She turned me into a newt. I got that. Everybody's different. And, some people, this person may be in very good shape. They may have just showed up in an acute crisis, but it turns out that they're a runner. They're extremely fit and they eat well. They're very motivated, to survive. And so even though it looked like it was going to take, a couple of days worth of treatment, to take care of this person. At the time the doctor admitted the patient, we thought it was going to take at least 24 hours.
Let me talk about that slide for a minute.
Okay, I'll go back.
Because this one occurs to me that, sometimes what happens is the physician did not write down, in so many words, I expect the patient to be in the hospital to midnight. But to me, this seems like this is a chance, it's not on the record, and it's not something you can point to in the record. You can point to other things in the record that point to that expectation as being reasonable, as being okay, he didn't say it in the record, he didn't write it down, but because of this and this and this, it would be a normal course of treatment that somebody could be expected to require at least X hours of treatment. So you can say that, it's almost like being able to add something to the record here, but you're again, this is a part of the proposed decision. So it's basically you arguing that it's reasonable for this to be assumed that the physician was thinking that way, even though he didn't write it down. I would think that's really a great way to be able to get this into the record.
Exactly. And so that, because you treated this patient, for those of you that are medical providers, for those of you who have representatives or are representatives, have been doing these for a while. you know exactly that this is why you want to have somebody at the hearing. Okay. You know, again, everybody's entitled to their opinion, but a representative has to prove it.
Yeah.
And so the best thing to do is to have somebody like Dr. Zhivago at the hearing who can tell you this, and or can tell the ALJ this. And again, then you or get a statement from the doctor. You know, if you're submitting this as a request for on the record with you know, your request for hearing, and you've you know, again, you've anticipated something, because a lot of ALJs are going to, you know, may fall for this red herring. Well, you know, they got better. They checked out against medical advice. It didn't take as long as whatever. You know, you have to.
Is that something that you can, for example, you can't have the attending physician come to it, but can you have them write a statement for this hearing?
Sure, absolutely. Absolutely, you know, and just have the doctor write, I declare under penalty of perjury the foregoing is true and correct. And,
okay.
You know,
does that occur as a way to deal with that? Because there are cases where the physician didn't write down an expectation. Now, I know I've heard payers saying, and it's kind of a reasonable thing, if there was no expectation, then there's no such thing as an unexpected recovery, because you weren't expecting them to stay. If you didn't say you expected them to stay. Now,
so you better stay.
This occurs to me that this is a great way to get around that kind of denial, is by when you finally get to this level, or that you're doing it in the proposed decision, which of course is going to go in probably long before you would ever get a hearing.
Right.
So that could possibly shorten the whole thing. And it just that sounds like a great thing to me.
Yeah, you know, and again, do it early. There may be a new evidence issue with this. I think you could address that if it comes up by saying, well, you know, we didn't know. This isn't in the medical record, and this is an issue that was brought up by the RAC or by the QUIC, and it didn't exist at the time of the reconsideration decision. If it certainly came up for the first time in the reconsideration decision, then, you know, I think you could beat the new evidence argument. But, you know, again, remember the slide, never give up. Yeah. All right. So the thing you have to keep in mind here is that if the Affirm Act passes, and I'm not sure what its status is now, you know, maybe Jess or Abby, if they're around, could comment on that at some point. But once the Affirm Act passes, the ALJ has to say why they disagree with it quick, you know. So, you know, on the one hand, it may seem like the Congress is making it harder for the ALJ to pay the case. Well, not really. Let's be appreciators. And, you know, since we're proactive and we're doing our jobs correctly, and, you know, we really believe in what we did for our patients, then what we're going to do is we're going to make sure that we get paid, and we're going to recognize that even if this wasn't in the law, the ALJ should be doing this. Or, I mean, we used to do it at Social Security all the time. You know, well, no, I don't believe the state agency doctor because they never ever saw the beneficiary. You know, or no, I don't believe this. You know, this person they sent him to for this consultative examination because they spent 5 minutes with a person, and there's absolutely no way they could have even examined, you know, all of the cranial nerves in that time thoroughly. You know, not to mention all these other things. And so, you know, again, you have to say why. You know, again, there's some boilerplate here.
Okay.
Those of you who are do we have a question?
No, I was just going to say,
okay.
I did while you were talking, I checked up on the Affirm Act. It's govtrack.us gives it a 39% chance of passing, which is actually a pretty high number from them.
Yeah. Well,
nothing been done on it since for about a year.
But, you know, so it hasn't been passed, but if it gets passed, it probably may not be effective as January 2017. But this is, you know, prepare your cases now. If you think you're going to have these kind of issues, or you start seeing these in the initial denials, and get these letters from the doctors and get them into the record right away, so that you don't run into this. All right, you've probably all seen this. If you're doing inpatient cases, you got a doctor that shows up and says the same thing every time. So here's what you do with that. You know, again, I mean, and you're putting, it maybe if you're asking for it on the record, you know, and you've got a doctor from the quick who never ever finds that there were, you know, anything wrong with the, you know, beneficiary, and you know, they're saying that, you know, blood pressure of 175 over 102 is, you know, the beneficiary had vital signs, then you point that out. So, you know, look, they always do this. They never find anything wrong with the beneficiary. You know, again,
Is this something where you could incorporate a statement like, I mean, we've always heard Jessica and Abby from Health Law Partners saying, you know, if the question is, you know, which of these services could, you know, which of these services only could have been provided as an inpatient? And the answer is all of them, because it has nothing to do with the service itself. It has to do with with the time. Well, these days it's about whether it's past 2 midnights or not. But it,
yeah.
Yeah. So is something like comments like that appropriate? Things that.
Sure, you could. Sure, yeah. But again, you're explaining. Here, you're explaining your disagreement. All right. Then you're.
Okay.
I think we get to. Actually, going to get to why you agree with why the ALJ should agree with you. But here's one more. Here's one more on discounting the prior decisions, and particularly the lettering in blue. Less weight than the other mice might merit. You don't want to give them no weight. You know, you don't want to give them no weight. What you don't want, you want to say less weight than the otherwise might merit. That's a pretty waffly way. I mean, that's just something I've seen a lot in decisions. And so you're saying, you know, I considered this, but I'm not giving it as much weight as it should get. And again, a lot of judges came over for Social Security. They're going to recognize this language. The other point here is that it says for these clear and convincing reasons, the standard of proof is a preponderance of the evidence, but there is case law for Social Security and decisions, and some of it has been held applicable to Medicare hearings, that if you're going to disagree with a treating physician, you have to have clear and convincing reasons to do so. So I think it's just best to be on the safe side that if you're going to disagree with one of these so-called experts, just do it for clear and convincing reasons. So again, the ALJ is going to look at this, the staff attorney is going to look at this, and they're going to see that you know what you're doing. They're going to see that you've been around. It's going to ring a bell with them, so to speak. And you know, again, people tend to go along with what they know and with what they already agree with. And so I'm missing a couple of pages here in notes. You know, and again, you only get 3 seconds to make a good first impression, and this is one way of doing that. All right. What do we do with our own? You know, we want to bolster our own people. You know, if you're offering the treating physician, if you're fortunate enough to have the treating physician or the treating therapist at the hearing, or the treating nurse at the, you know, unlike the RAC expert, this person actually examined and treated. You know, this is the gold standard, supported by clinical findings, including whatever, and are consistent with the record as a whole. Therefore, I gave them great weight. You don't want to say controlling weight. You don't want to say, therefore, I adopt them. You know, controlling weight makes it sound to the Medicare Appeals Council like the ALJ is giving in to the treating physician and not exercising the independent duty to make an independent finding as to whether the case should be paid or not. And if you say, I adopt the findings, then you might be running afoul of this change that we talked about earlier. So, you know, I gave them great weight. And you want to talk about, you use the term conclusion, because conclusion is persuasive. Conclusion is something that is supported by the evidence. You know, everybody's, you know, there's the old story. Everybody's, you know, opinions are like navels. Everybody's got one. Opinion is not as strong a word as conclusion. This is something that my supervisor at Social Security taught me, and I think it works very well. And so, again, this is how you can advocate for your client. This is the standard conclusion in every decision. All right.
Okay.
Right. This seems like it's a lot of work, and there is. But you know, if you want to go the extra mile, if you want to get paid more often, you want to make a good impression for a client, we have to do the work. And so what do we do with all this? All right. Well, we're going to do this hot pink cover sheet, which is going to wake everybody up and get the ALJ's attention. And they got mounds of white paper there. And it's, this is going to stick out like a sore thumb, So you give them the cover sheet, you give them that brand new copy of the records, and you explain that this is a copy of records that were previously submitted to the quick or whoever. And so therefore you don't run across new evidence, probably get a page number them. Again, so number one, somebody doesn't have to stick it through a page numberer or number it by hand when the bloody machine isn't working. And I can't tell you how many times people go, well, now, the machine isn't working. And I used to number them by hand because it's just, for me, I'm old. I'm not that old, but I just couldn't figure out. Show me how to run the machine and how do you make it number. It's just easier to pull a pen out and, number the pages by hand. So somebody doesn't have to number it. And then you're helping the ALJ. They're going to pick this thing up and so they're going to say, well, all right, so where's the inpatient order? Where's the order changing status, or where's the order showing that her, she crashed, or that his blood pressure, or that he couldn't breathe, whatever it was that, you're asking the ALJ to hang their hat on. And they can pull out that copy of the records and go right to that page. They're going to see it, and boom, you're going to get paid. And then you send them, of course, the proposed decision, and then you send them a CD. Okay, not a floppy disk. You just burn a CD and send it to them in Word format, and there you go. So as we conclude, what have we done here? We got the ALJ's attention. We made a good first impression. You get paid sooner, and you have a chance to serve.
And so, my fellow Americans, ask not what your country can do for you. Ask what you can do for your country.
And I'm really serious about that. Call me naive. Call me whatever. But I think we all, as I said at the beginning, and as the saying has been for centuries, the gods help them that help themselves. And so what you're doing is you're making it easier for these overworked people. And I'm not necessarily saying the ALJs, they get paid good money, but particularly the legal assistants and some of the staff attorneys, and you want to get paid sooner than later. And so anything you can do to help these people help you, they're going to appreciate it. And, again, it's going to make a good impression for you and for your client. And believe me, they're like Santa Claus. They have lists. And they check them twice. Really, they do know who's naughty, but more important than that, they do know who's nice. And so then if you have to appear in front of that ALJ with a case that's really iffy or that's really difficult, you're walking in there with, you're on second base or third base instead of having to start, fresh. So I think, this here's something, you can look at this later. What if the Ed Quick takes a no motion review? Here's an order. That you can send the ed. Well, the ALJ pays your case, and it goes down to the administrative quick, which is Q squared, down in Columbia, South Carolina, and they look at it and they don't like it, and so they decide to send a letter to the Medicare Appeals Council saying the ALJ messed up, and you should look at this case on your own motion. And so if you get one of those, here's what you send. This is the format, but you don't put in the Milton Friedman quote at the top. This is the quote from my book. And that's in particular for a doctor down at the Ed Quick. He knows who he is and he knows who I am. They used to look me up on LinkedIn, when I was an ALJ. But seriously, so you send them a letter like this, order denying them, and it's really important to respond to these things. Because you don't want the Ed Quick to be the only person the MAC hears from, particularly when they really bollocks it up, as my friends across the pond say. Your continuous glucose monitors, the contractors are paying those cases, and you've had somebody down at the Ed Quick, every time somebody paid one, they file an own motion review. And, so this is just some boilerplate for that. So the same principles apply. So that's all I have. We have about, I think, 10 or 15 minutes left. And so if anybody's got questions, I'd be happy to answer them.
I want to go back and talk about that. What was I thinking? Back on the cover sheet, the hot pink cover sheet.
Oh, right. Okay.
Because you got in there, I wanted to talk real quickly about Because there's some people who didn't hear you talk about the elevator pitch.
Oh, right. Yeah. What's an elevator pitch? Remember, it's what you'd say. Remember when Harry met Sally and he rode the elevator. I rode the elevator 4 more floors just so I could keep talking with her. Well, what if you don't get 4 more floors? What if you just, you meet the love of your life, or the ALJ says, why should I pay this case? Or, those of you that remember the presidential debate, with the late Senator Kennedy, why do you want to be president, Senator Kennedy? What would you say if you only had a minute to make your case? That's also your opening statement. So it's the 59-year-old beneficiary. On Tuesday, Mr. Smith's doctor gave him a new medication. Wednesday morning, he woke up, he couldn't breathe because his face and mouth were swollen. An ambulance took him to the emergency room where they bolused him with steroids and they sent him up to the intensive care unit. And he was in the intensive care unit for another 2 days before he went home. They gave him this albuterol and, oxygen and water and everything. And this was clearly an acute level of service. I mean, right now, you've got the ALJ's attention with that right away. And so you put that on there, medication change, anaphylactic reaction to medication change, requiring massive dose of steroids, put in the intensive care unit. I'm not saying that the case should be paid because he went to the intensive care unit. I think the manual says the location of the services does not direct payment. But the fact that they gave him this massive dose of steroids and they sent him to the ICU tends to show that this wasn't observation. They weren't keeping him here to see if he'd get better in the morning and they could send him home,
It wasn't something they could have done at the physician's office or something.
Right, exactly. So, it's just what would you have to say, or if your spouse or significant other said, so what's this big case that you have, coming up? You could, and you talk about it in generalities, of course, but this is what you would say. So, yeah, that's another. And so, yeah, I'd encourage you to put the elevator pitch in there. So that they look at it right off the bat. Holy Toledo, this person was in the ICU. Anaphylactic reaction, that's really serious, or, 71-year-old beneficiary who is still working full-time and cares for a developmentally challenged adult child, needed to return to full functioning as quickly as possible after a double joint replacement. And again, they're going to see, wait a minute, so this person probably needed acute inpatient rehabilitation, the specialized treatment that comes in an IRF,
Okay.
So that's what that is.
We got two good questions.
Good.
Amen. First one.
Oh, yeah. Hi, Dr. Katz. How are you?
Yeah. First one is what in the proposed decision might change under the 2 midnight rule? That is, the law cited or appropriateness of the second midnight, something like that.
Well, I hope that you're not going to see. I don't think you're going to be seeing as many of these cases under the 2 midnight rule because the issue. I mean, it's going to be pretty clear cut. If the person was in there for 48 hours, theoretically, CMS ought to be paying that, and the contractors ought to be paying those cases. Although I'm told what they might be looking at, well, this person didn't need to go to the hospital at all. I don't see how you could do a joint replacement outpatient, and I don't see how you could, do some things, in a doctor's office. But obviously, you're going to just use a different set of rules. You're not going to quote the 24-hour, the expectation of 24 hours. You're going to say, look, the person was here for 2 days. Or this could not have been done in an outpatient setting. I mean, I think the only issue under the 2 midnight rule, and Justin Abbey, could tell me if they're wrong, is I mean, were they in there 2 days or not? 2 midnights or not? Does that answer the question?
I think it does, because I think it's the appropriate. I think you want to get back to just how you said about you're citing the facts. Then you cite the relevant regulation that relates to it, and then you definitely point to the fact that the facts support support the admission because they meet the requirements of the regulation.
Well, yeah, and actually the really relevant portion of this question here is the appropriateness of the second midnight. They shouldn't be questioning the appropriateness of the second midnight. That's Monday morning quarterbacking. And as I understand the 2 midnight rule, if they were in there, I mean, you can't admit somebody for two midnights, to suture a cut or something. But I don't really think the Racks will probably try and figure out a way to get around it. But I really, in my personal opinion, and my judicial opinion, I don't think it's going to be as appropriate for somebody to be questioning. They didn't really need to be in there for 2 midnights. No, CMS has clearly set forth a policy. If you're in there for the second midnight, we're going to pay it as an inpatient. And
yeah, but then it does become like, well, if you've got a social admission, you don't have an argument. So
yeah, if it's a social admission, right? But I mean, if it's a medical
for convenience, yeah.
No. I mean, but other than that, they shouldn't be doing it. All right, next question
was
from Dr. Katz. How are you? Yes, I think quoting literature with evidence-based medicine will help us persuade the judge, but it's got to be relevant. So, for example, if it's a question of somebody having a TIA and you want to say, well, people who are kept in people who are kept in a hospital for at least overnight do better, then the study better say that. The study better say people who are admitted as inpatient and receive these services, whatever you're submitting better back up the actual argument that you're making. There are people who are going to read every page of that article, and particularly now with a lower payment rate. And we had a question during the RAC PAU or boot camp, about what are they teaching the ALJs now. And so I'm sure one of the things that they're emphasizing is, you got to read every page, make sure these things are on all fours. An article, if it's short and it's helpful, and if it's got pictures, even better. But make sure it really applies to the case. And anaphylactic. Not everybody's going to know what an anaphylactic reaction is. Not every starting ALJ is going to know what a lesion of the LAD is. Those have been around for a while. We're going to know that. So again, not everybody's going to know what tissue plasminogen activator is. But you could say, so the doctor gave him a clot buster, TPA. Everybody's going to recognize what TPA, what a clot buster is.
Yeah, clot buster. I don't know what a TPA is, but I would know what. It dissolves a clot in somebody who's having a stroke. But it's important to keep in mind that even some of these ALJs may be pretty darn new if they get to hire all these new ALJs. So they're not clinical. Their staff may be more clinical than the judge may be, I guess. So you've got lay terms.
Yeah, again, what you want to do is you want to make it as easy for the judge to understand this as they possibly can. Again, they're not, some of them came over from Social Security. They're going to know medical, but the ones who didn't, the ones who didn't do personal injury law, don't know. There's a couple of the ALJs. I understand at Omaha, or people that used to be staff attorneys there. So hopefully that person's is going to know what this stuff is. After having been with the agency for 5 or 10 years.
Yeah. Okay. Well, I think that's we're out of time. But any other? Okay, here we are. One more from Dr. Katz. Anytime a clinical term is used, I explain what it means in lay terms to the judge. Yeah, good.
Absolutely. And there's no ALJ, I think, who would take offense at that.
Yeah.
The ALJ would probably explain a term called ex parte to a rep who wasn't an attorney, and who didn't know about those kind of things.
Yeah. Okay.
So.
Well, any further questions that you all have, you can definitely send them to Bob or to me, and I'll get them to him. And where was you want to show that slide with your email again?
Oops. Yeah, there we go. So yeah, I'd be happy to answer any questions. I seriously want to thank everybody who's shown. I know everybody's busy, and you got things to do. And you know, we had one person who said, "Yeah, I'd like to come, but I actually have a hearing starting at 2:00, and so they weren't able to join us." But I realize everybody's time is limited, and you chose to spend an hour of it with us. And I hope that this has been helpful to you. So I appreciate your confidence in me. And yeah, there's my email address.
Yep.
And it just, yeah.
Thanks, Bob. That was terrific again. And
Thank you.
Again, any questions, send them in to us, and we will talk to you some other time. And I hope we'll see you again on Finally Friday sometime.
Okay. Thanks, everybody. Have a good afternoon.
Thanks. Bye-bye.
Bye.